Hi there. A very common issue that comes up when I'm consulting with my clients or prospective new clients is the issue of a child or children's preference on where they're going to live post-separation or post-divorce. My clients often ask it kind of in this way: at what age do my children or my child get to decide which parent they're going to live with? Sometimes it sounds more along the lines of, at what point does my child's voice get heard in deciding what the custodial arrangements are going to be? And it's a very, very important question. Most frequently, it comes up when there's a dispute as to what the custodial arrangements are going to be, especially when one parent is either hearing something different or not accepting what my client might be telling me they're hearing from the child. So the answer to question one, at what age does my child get to decide where they're going to live, I kind of always answer with some version of, well, at what age do your children get to decide if they're going to go to school, if they're going to drink at home, if they're going to smoke? There are certain things that children don't get to decide, right? The answer to question two, kind of at what point does my child's voice or their preference get to be considered or heard in this process, is more complicated. And it's more of a nuanced answer. And the first stop on this kind of journey is the first people that need to consider what the child is saying are the parents. After that, it can get awfully tricky, and then kind of the classic lawyer's answer is, it depends. The general rule, I would say, is the older a child gets, the more their preference will matter or have an impact as to what their custodial arrangement will be, what their schedule will be. But it's not a matter of what the child wants, it's what the child's preference is in the greater context of what's in the best interest of the child. So you have to kind of ask the question, does the child or children prefer one parent's home or residence over the others for like a rational or understandable reason? Maybe one parent is a yeller. Maybe one parent works really long hours and they're just not around as much. But there's also kind of other reasons out there. Maybe one parent allows young kids to eat chocolate for breakfast. That's my kind of silly example. Maybe one parent allows a teenager to have their significant other, their boyfriend, girlfriend, whomever, come over unsupervised and hang out in the basement or in their bedroom. Obviously that could be very appealing to a teenager. But is that the best parenting practice? I don't know. And then there's also kind of, if anyone has done a Google search, there's all types of underlying reasons out there, and one of them is parental alienation that often comes up or is alleged in high conflict custody cases. But one of the most difficult parts of these cases is determining whether the child's resistance or preference is for a good reason, for lack of a better word, or not. And then twofold, being on the same page with the other parent about that. If the two parents, like I said earlier, are not on the same page, you have the recipe for a high conflict case. And what can be done about that is in one sense limited, and in another sense not very limited. It's limited in the sense that the adult's attorneys have no business interviewing the child, talking to the child, contacting the child, and saying, why do you want to live with mom versus dad or dad versus mom? And so as the adult's attorney, you're stuck in a game of telephone. But what attorneys that are representing parents in the situation can do is they can make certain requests of the court system. And there's two very kind of but two main remedies that come to my mind. And that is, you can ask for a court-ordered custody evaluation, often conducted by an LCSW, which is a licensed clinical social worker, or a PhD psychologist who will meet everyone, interview everyone, do home visits, and make a recommendation as to what the best schedule would be. And in that process, the child's preferences would come to light through various interviews. There is also the avenue of having an attorney represented to represent the interest of the child. And I'll go into this in future videos, but the most common appointed attorney for that purpose, court-appointed attorney for that purpose, is what's called a best interest attorney. And that attorney's job is to represent the child or children in the case as if they were an adult client. conduct discovery, make arguments to the court, file paperwork with the court. And through that process, again, meeting the clients, now I'm talking about child clients, meeting the clients, interviewing them, interviewing their parents, interviewing significant third parties, maybe grandparents, teachers, people that are involved with the child in other ways, whether it's clubs, activities, scouts, the like, to get in, and especially if the child or children is seeing some form of therapist or counselor, getting a picture of what's going on in this child's world, and then advocating, although that's a tricky word in this context, representing that child's interest to the court. Now, as I said, I'll get into it in a later video, what the child thinks is in the child's best interest or the child's preference, and what the best interest attorney ultimately thinks is in the best interest of the child might not match up. Again, from what I talked about earlier, a younger child might have kind of immature reasons for wanting to live with a certain parent over another, whereas there's a whole different kind of calculus for an older child when it comes down to why they want to live with a certain parent. Ultimately, as children get to the ages of 15, 16, and 17, the court system kind of has a lack of ability to tell the child, you're going to live here over their objection. At that point, especially in today's world, with access to app-based travel companies like Uber and things like that nature, the kids the phrase is they vote with their feet. And the older the kids get, they can say, oh, well, there's a court order that says I'm supposed to be at dad's house. I don't care. I'm going to mom's house. If they can drive, they have access to a vehicle, they might walk out of dad's house and go drive right to mom's house and not come back. Anyone who practices family law for long enough, has come into a case like that. And there's, to a certain degree, the court doesn't have a magic wand, and the court doesn't have the resources to assign a deputy to kind of walk the child from house to house on their court-ordered scheduling time. So there's no clear answer. There's a lot of gray, but like I said, the general rule is it matters more as the child gets older. And I think what's important here is if you're involved in a case like this, there are avenues to investigate what would be in your child's best interest based on their preference through a custody evaluation or the appointment of a court-appointed attorney for your child, whether that is a best interest attorney or a child advocate attorney, which I'll discuss in another video. If you have any further questions about the impact of a child's preference on a custody case, do not hesitate to contact my firm, Weinberg Schwartz, at 410-997-0203. As always, if you have any additional questions about myself, my information is in the bio of this video that you're watching. And as always, please feel free to like, share, and comment on this video. And I will see you next time. Thank you very much. I appreciate you watching.